Hello, how are you? I hope you all are fine. Let's today discuss the topic of attempt to murder under section 109 of Bharatiya Nyaya Sanhita. Earlier, it was under section 307 of IPC. Now, attempt to murder is in section 109 of Bharatiya Nyaya Sanhita. What is attempt to murder? You see, whenever a person does any act with the intention or knowledge that by doing that act, that particular act, he will be guilty of murdering a person. He will be guilty of the offense of murder. And in case by that act, the person against whom that act was done fortunately lives, he fortunately does not die, he is not killed by that act, he does not die by that act, he lives, then the person who is accused of doing that act, though he will not be guilty of murder, but definitely he will be guilty of attempt to murder, because he had the same intention or knowledge of a murderer. He knew that after doing that act, the person will be killed. Though fortunately, by God's grace, the person does not die. But even then, the person who has committed this act, he will be guilty of, though not murder, but he will be guilty of attempt to murder. He had attempted to murder him. There are certain illustrations in your Bharatiya Nyaya Sanhita, section 109, if you read it. And one of the important illustration is a person with the intention of causing death of a child exposes that child in a desert place, and there is no living person there or human being there. And in case he leaves that child there, and fortunately the child does not die, he lives, somebody comes and pick it up, then the person who has left that child there with the intention of killing that child, he will be guilty of attempt to murder. Why? Because he had the same intention and knowledge as a murderer has. He knew that the child will die without any assistance or help from anybody. Though fortunately somebody picked up the child afterwards and the child was saved. But even then, the person who did this gruesome act, he will be guilty of attempt to murder. Then the second illustration is that A, intending to murder Z, buys a gun and loads it. So he buys a gun, A buys a gun, he loads it, and his intention was that by that gun he will murder Z. Now he keeps that gun in his house. Up till that point of time, there is no offense has been committed. No offense has been committed by A. But if he in the next morning picks up that loaded gun and he goes to Z's house and he fires at him, he fires at Z, he has committed the offense of attempt to murder, though Z is saved afterwards, or Z fortunately used certain tactics to save himself and the bullet didn't touch Z, but the intention of A was to kill Z, and fortunately Z saved himself by his defenses. Even then, A is guilty of attempt to murder, because he had the intention of killing Z. He had the intention and knowledge that once he has done this thing, this act of firing at this Z, he will be guilty of murder in the courts of law. Fortunately, Z is not killed. Even then, A is guilty of attempt to murder. And one thing more, if a person is held to be guilty of attempt to murder by the court, he can be put behind bars for up to 10 years, and fine will be also there. But if actual hurt has been committed, if the person against whom this act has been done, he suffers some hurt, then the accused person can be put behind bars for up till his life. He can be sent to jail for life imprisonment. Yes. So through your act, if some hurt has been committed on the person who has been targeted by you, he suffers some hurt by your act, though you have the same intention to kill him. You knew that he will be killed by you, and you knew that you will be guilty of murder. But fortunately, he doesn't die, he lives. But he suffers some hurt through that act. Then you can be sent to jail for your life. You can be guilty of life imprisonment. And in case you are already in the jail and suffering life imprisonment for some other offense, and in jail you did this thing, you attempted to murder somebody, then you will be, you can also be guilty of death sentence. You can be guilty of life imprisonment also, and you will be given death sentence. You can be given death sentence because you are already suffering from this attempt to, you are already suffering from this life imprisonment in some other case, and you have done this thing, attempted murder in the jail itself. So you can be guilty of this attempt to murder, and because you are already in you are already in jail suffering this life imprisonment in some other case, then you can get capital punishment also. So those who are not in jail already, they are not suffering from any sentence through the court of law. If they do such act, they can be put behind bars for 10 years or life in case they hurt the person. Because in attempt to murder, the person against whom the act is done, he never dies. And in case he dies, and the MLR report or the medical legal report or the doctor's report says that the cause of death was directly because of the injury given by the accused. For example, there is a firearm and the accused fired at some person, B. A fires at B, and the bullet just touched that B on his chest. This is not a deep injury there, it just touched his chest, and there is profuse bleeding there. Though a normal person, if he gets an injury here in chest and the bullets just run away from here and there is not a deep injury, he will not die. But unfortunately, that person dies. But the medical legal report or the doctor says that he didn't die because of the shock given by that bullet. Generally, if some person is hit by a bullet, so he gets a shock, and because of shock he dies. Now that death is directly related to the bullet injury. So the person who is committing that act, he will be guilty of murder. But in case if the bullet did touch the body of the person and the doctor says in his report that there is not a deep injury there, and the death is not directly related to the bullet injury, death was due to bleeding, but that bleeding is nobody gets so much bleeding in such type of injury. It's a very less or very rare injury, and that death is not because of that injury, death is not because of the shock or brain hemorrhage or heart attack, which is directly related to that bullet injury. Then even then, if the person dies, the accused or the person who has committed that death of the other person, he will not be guilty of murder, he will still be guilty of attempt to murder, because that death itself is not directly related to the bullet injury. Though because of profuse bleeding he died, but The doctor's report says that the death was not due to bullet injury, it was because of some other weakness or illness of that person, and that illness or weakness was not known to the accused, because had he attempted the same act on some other normal person who's a healthy person, he would never have died. But because of the person who has some illness and weakness, and because of profuse bleeding, just with simple injury of a bullet, he dies. It doesn't mean that the person who has committed that death, he will be guilty of murder, because he didn't knew about that illness or weakness of the person. He will still be guilty of attempt to murder. This is an exceptional case, but generally in most of the cases of attempt to murder, the person doesn't die, he lives. But because the person who has committed this act, he knows and he had the intention that he will be guilty of murder if he had done that act, then he will be guilty of attempt to murder, because fortunately the person didn't die because of this act. So this is the minute difference between murder and attempt to murder. So this was the thing. So I think there's one more example. If a person fires at some other person at point blank range, you know what's point blank range? He's very near to the person who he is targeting. So he fires at the person at a point blank range, and fortunately the bullet didn't hit the person's body, because actually bullet hit some purse under his coat. There is some purse or leather wallet under his coat, and that bullet touched that leather wallet and it didn't pierce into his body or hurt. He somehow is saved from that injury. He didn't die because of that leather wallet. But even in this case also, the person who has fired on that person, he will be still guilty of attempt to murder, because why? He knew or he had the intention that if he has done this act, he will be guilty of murder in the court of law. So still he will be guilty of attempt to murder. So this was the video related to attempt to murder. In the last, I would say that those who are very serious of preparing for judiciary exams, those who want to become judge, they can call me, they can WhatsApp me. My number is 9646526942. I repeat, 9646526942. Especially those who are preparing for Punjab judiciary, Haryana judiciary and Delhi judiciary. They can WhatsApp me, they can contact me, and I will give you details of the course of judiciary exams. Thank you very much.